Hi everyone, I'm attorney Kelly Longtin from Kelly Longtin Law. Welcome to our YouTube channel, where every week or every month we drop different videos to help all of you understand estate planning and how it can benefit your family. Please like and subscribe our page, hit the notification button. Today we're going to talk about if I leave someone my home, what do they actually get? Your home is likely one of the most valuable assets that you own, if not the most valuable. Calling it an asset can sound cold. A home is far more than an assortment of materials and possessions. It's also a place to live, gather, create life stories, and share memories. However, in the eyes of the law, your home is a collection of several types of property, along with their associated property rights. When the time comes to pass your home on at your death, the law, rather than any sentimental attachments or fond associations with the house, is what matters most. Leaving my home to someone can mean different things to different people and to the law. The only way to ensure that your gift is received exactly as you envision it is to spell out the details in your will or trust. That process involves considering not only the property itself, but also what is in it, what is attached to it, and what financial strings are tied to it. So let's talk about what my home means in legal terms. It's common to use words and expressions in everyday conversation that carry a different meaning in legal terms. Telling a friend that you are giving your old car to your nephew might suggest a simple handover of the keys, but legally it could require a complex transfer of title and registration, refinancing a loan, and payment of any resulting taxes. Taking care of a friend's dog may imply feeding and walking it for the weekend. Depending on the situation and state law, however, agreeing to care for a dog may also mean taking on legal responsibility, such as being held liable if the dog bites someone. Similarly, when we say my home, we usually mean the whole package: the house, the land that it's on, including the front and the backyards, and even the furniture and belongings inside. In legal terms, however, each of those elements is distinct and has its own rules for transfer, ownership, and inheritance. So while you may say in a will or trust that you are leaving my home to someone, the law does not automatically treat home as one indivisible object. Instead, it sees separate legal components that may or may not be included in your bequest, depending on the wording. Generally, when you leave a house to someone in your estate plan, you are giving them what the law calls real property. But what is actually included is that term may not be obvious, which is why the wording in your will or trust matters. Being precise ensures that you transfer exactly what you want, no more and no less. So let's talk about what to consider. There's obvious inclusions when you say my home: the house and the land. The physical structure, the house itself, and the land it sits on are typically transferred together as real property. For example, a single-family home at 123 Maple Street includes the house and the surrounding land described in the deed. Now, fixtures. Fixtures are items that are permanently attached to the home, such as built-in cabinets, ceiling fans, lighting fixtures, and air conditioning systems. Fixtures are considered part of the property and are usually included when real property is conveyed, and thus they are explicitly excluded. For example, if you want to leave your antique chandelier, which is normally considered a fixture, to your niece, you must include language in your estate plan, making it clear that the chandelier is excluded from the gift of the home to someone else. So let's talk about some not so obvious inclusions in my home. The house, the land, and everything permanently attached to the property are almost certainly included when you refer to my home in your estate plan. However, the following types of items in the home may not be part of the transfer unless you specifically include them. The first is personal property. Items such as furniture, rugs, artwork, collectibles, and portable appliances are generally not included without a specific provision in your estate plan to the contrary. The same goes for items stored in the attic, basement, or garage. Now let's talk about appliances. Built-in items such as an oven or cooktop that is integrated into the cabinetry are often considered fixtures, while freestanding ones such as a refrigerator, washer, or dryer are typically considered personal property and do not automatically transfer unless specifically included. Now, some people want all the personal property in the home to transfer with the home, while others would rather it go to someone else. For those who want to include it with the home, they may identify the gift in their estate plan as the home and all its contents. However, an all contents clause is not a foolproof solution for avoiding ambiguity. Courts often narrowly interpret phrases such as all its contents or everything in the house to mean only the household goods inside the home, not items stored off site. For example, imagine that your will says you are leaving my home and all its contents to your daughter. She reasonably assumes that this means the furniture, dishes, and artwork inside the house. However, you also keep valuable jewelry in a safe deposit box at the bank, and a classic car in a storage unit across town. Because those items are not physically in the home, they may not be legally included in all of the contents gift. This could mean that your daughter does not inherit them, even if that was your intent. If you do not use an all contents clause, another issue can arise. Many estate plans include a catch-all provision that says something like all remaining personal property goes to so-and-so. In practice, such wording means that anything not specifically mentioned elsewhere in your estate plan, such as furniture, household goods, or jewelry, will go to that individual. The problem is that the person may not be the same one who inherits your home. If you assume that the household belongings would automatically go with the house, but your estate plan directs all remaining personal property to someone else, the result can be an unintended split. One person ends up with the house while another gets everything inside of it. You want to really pay attention to fine print. Private property rights are ultimately governed by contract law. However, even if you have lived in your home for decades, you may never have read all the fine print in your original purchase documents. Indeed, explaining the exact rights and restrictions you received when you purchased the property. As with the contents of your home, these provisions should be recognized and addressed in your estate plan, so your loved one knows exactly what they are getting and not getting and can plan accordingly. There's also easements and restrictions. If your property is subject to certain types of easements or restrictions, your beneficiary will also inherit it with those limitations. For example, a neighbor's right to use a shared driveway or local or community rules prohibiting certain renovations can affect how the property is used. Let's talk about mineral and air rights. Mineral rights, such as ownership of oil, gas, gravel, and other resources below the surface, and air rights, including the ability to control the airspace above the property, are separate development rights. Though these interests may have already been sold or leased by you or a prior owner, and if they have not been, they may still be separate from the land and may not automatically transfer with the home unless you specifically include them in your estate plan or deed. For condominiums or townhouses, the beneficiary typically inherits the individual unit itself, while the land or common areas, such as pools, hallways, or shared landscaping, remain under the condominium association's control. Now, the home will transfer to a beneficiary subject to existing debts or liens such as mortgages, property taxes, or other creditor claims. These obligations do not disappear at death. The beneficiary inherits them along with the property. When my home does not mean what you think it does, let's talk about that. The intersection of casual language and legal language is usually not a major issue. Your family and friends, unless they're lawyers, are likely or unlikely to notice or correct you if the two are out of sync. However, you cannot make this assumption in your estate plan. Lawyers and possibly judges will be reviewing your words very closely after you pass. At that point, you will not be around to clarify what you really meant. Common parlance does not work in an estate plan. To avoid ambiguity and unintended consequences, you must choose your words carefully. So let's talk about some scenarios. First, you have an empty house. Let's just say a father leaves my home to his daughter. When she reads his will, she discovers that the gift did not include any personal property inside the home. Every piece of furniture, all the appliances, and even the area rugs are governed by the estate's personal property catch-all clause and go to other beneficiaries. There's also the unbargained for mortgage. A niece inherits her aunt's home only to discover it still carries a substantial mortgage. Because the aunt's estate plan did not direct the estate to pay off the mortgage first, the niece faces a tough choice. Either assume the loan and continue making payments, or sell the property, pay off the mortgage, and keep the remaining proceeds from the sale. And let's talk about when there's multiple parcels. A man leaves my home at 125 Oak Lane to his daughter, believing that this gift includes the entire property she has known all her life as home. However, he also purchased an adjoining lot under a separate deed. Because the adjoining lot's legal description is separate from the legal description of 125 Oak Lane, it is not included in the man's gift to his daughter and goes to the other beneficiaries. If the daughter wants to challenge this outcome, she will likely have to go to court and try to prove her father's intent. Now let's talk about the condo caveat. A grandmother leaves my condo to her grandson. He inherits the unit but soon discovers that it comes with hefty condominium association dues because of the community pool, gym, and common landscaping. And what if there's a remaining roommate? A father's estate plan leaves my home to his son, but also gives his son's stepmother the exclusive right to live in the house for the rest of her life. This means that the son does not gain possession of the home until his stepmother passes away. Under the father's estate plan, the stepmother must pay all utilities while she lives there, but the estate is responsible for property taxes, insurance, maintenance, and repairs. Over time, these expenses can significantly reduce the amount of the estate's funds that were intended for the son. Now, each of those scenarios that I just mentioned or discussed with you, and many others that I didn't mention, can be avoided with clear instructions within your estate plan that couch every contingency in the language of the law and leave nothing to the imagination or to the court's interpretation. Now, there's some ways to ensure that your home and everything you intend to go with it passes to your beneficiaries without undue confusion or complication. The first thing you want to do is use specific wording. Name the property by its street address and legal description. List any additional parcels or lots that should be included. You also want to clarify what is inside and outside. Specify whether furniture, appliances, artwork, or other personal property, including non-obvious items such as outdoor equipment, are part of the gift. Also consider belongings stored off-site, such as in a storage unit or safe deposit box, if you want them treated as part of the gift of the home. An attorney can help you create a detailed list of all of your assets. You want to address debts directly. State whether mortgages, liens, or property taxes should be paid from the estate or assumed by the beneficiary. There's always maintenance funds. You may allocate funds from the estate for property upkeep, taxes, or homeowners or condo association fees to ease the beneficiary's financial burden. You also want to make contingency plans. Name alternate beneficiaries if the primary beneficiary cannot or will not accept the home. You also want to account for rights and restrictions. If there are easements, mineral rights, community rules, or other limitations, acknowledge them in the plan so your beneficiary is not blindsided. You also want to review and update your plan regularly. Ownership, property boundaries, and your wishes can change over time, so you want to update your will or trust to reflect your current reality. A home is a generous gift, but it can also come with burdens, both anticipated and unanticipated. To know for certain what rights and restrictions and property accompany a gift of my home, and to prevent a beneficiary from receiving more or less than they bargained for, you want to work with an estate planning attorney to make sure that you get those transfer details correct. Clear communication in the present in your estate plan can help avoid family disputes, unintended beneficiaries, unexpected liabilities, and other situations that could impact home ownership. So to learn more about the best way to leave your home to your loved one, reach out to a qualified estate planning attorney that practices in the state in which you reside. So I want to thank you all for watching. I'm attorney Kelly Longtin. Please like and subscribe. Hit the notification button so you can be alerted about new videos as they drop on our channel, so you can stay in the know about all things in regards to estate planning. Until next time, I hope you all have a great week, and I look forward to having you watch more videos so you can learn more about estate planning.